You got hurt at work, you're trying to recover, and one of the first questions that comes up, maybe from you, maybe from your family, is, what's going to happen with my job while I'm out? It's a fair question, and the honest answer might surprise you. Let me break it down. I'm attorney John Sheehan. Since 1993, I've represented thousands of injured workers and car accident victims throughout Massachusetts. I fight to ensure that each client receives the compensation and medical treatment that they're entitled to without getting taken advantage of by an insurance company. And if Spanish is easier for you, hablamos español. This video is general information only and not legal advice for your particular situation. Here's something a lot of people assume, that filing a workers' comp claim automatically protects your job. Well, that's not exactly how the law works in Massachusetts. An employer is not legally required to keep your job open unless there is a specific employment contract or a union collective bargaining agreement that says otherwise. In most cases, employees in Massachusetts are employees at will. That means your employer can end the employment relationship for a legitimate reason, or for no stated reason at all. So the honest answer to, do I still have a job, is, it depends. Your employment relationship, your contract, whether you're in a union, all of that matters. Now, and this is important, there is something your employer absolutely cannot do. Your employer cannot take adverse action against you because you filed a workers' comp claim. That's retaliation, and it is illegal in Massachusetts. Here's what retaliation can look like: firing you shortly after you file a claim with a vague or shifting explanation, cutting your work hours when you return to work, demoting or removing responsibilities without a legitimate reason, excluding you from meetings or projects you used to be part of, creating a hostile work environment to pressure you into quitting or dropping your claim. None of these things are legal if the real motivation is your workers' comp claim. The key word is motivation. If your employer has a legitimate, independent reason for a personnel decision, that may be lawful. If the reason is that you filed a claim, that is not. Here's what I tell clients who are worried about this. Document everything: dates, conversations, changes in how you're being treated. If something starts to feel off when you come back from a workers' comp leave, write it down. That documentation matters. And if you are released to work with medical restrictions by your doctor, your employer may decide whether or not they can accommodate those restrictions. That decision is theirs to make. It can get more complicated if the restrictions your doctor recommends are long-term or permanent. In those cases, your employer may decide that they cannot accommodate you, and that can affect your workers' comp situation in ways that are worth understanding before you find yourself in that position. A lot of people don't realize that even in an at-will employment relationship, there are legal lines an employer cannot cross. You have rights, and those rights are worth understanding before you assume the worst, or before you quietly accept something that isn't right. If you've been hurt at work and you're wondering where you stand with your job, with your benefits, with your employer, the best thing you can do is get informed. A phone call to our office costs you nothing. And in that conversation, we can talk through your specific situation. If you have questions, I encourage you to call our office. The consultation is free, no obligation, no pressure. I'm attorney John Sheehan, and if Spanish is easier for you, hablamos español.